Thank you for joining us today for our monthly webinars that we do. My name is Katie Busbee. I'm an employment law attorney here at Haynsworth. And so today we're going to be talking about updates with your employee handbook. We're going to be talking about some new laws that came out this year and some things you need to be aware of as you are evaluating your employee handbook, some things that may need to be updated. And so we felt like this time of year is a good opportunity to talk about this. As we go into the new year, you can roll out any new procedures or handbooks that you may need to reevaluate. So before we get started, a little bit about our law firm. So HSB is a full service law firm. I know y'all are here today for some employment law talk, but if your company has other issues that it needs help with, we can also provide those services for you. We have 110 attorneys, give or take, across the Carolinas. So if you need any other services for your company, please reach out to us and let us know. So you can submit questions today via the chat feature on Zoom. You can just type your question in there. I'll try to do my best to monitor it, and Brittany, who's also on, is going to help me monitor a little bit so that I can respond as we go through, and hopefully reserve a little bit of time at the end to also respond to questions. This presentation will be shared with you after we're finished, so the recording and then also the slides. And this course has also been submitted for SHRM, HRCI, and CLE credits. We always have our little disclaimer here for our webinars that nothing I say on the webinar is legal advice. So if you have specific questions about different specific things going on in your workplace, please do reach out to us. We're more than happy to talk through those issues with you, but today's advice is just a general overview of the law and employee handbooks, and nothing here is legal advice. Okay, so we are going to be talking a little bit about what should be included in your employee handbook, some important provisions around discrimination and harassment. We're going to talk about some FLSA guidance with your wage and hour laws, drug policies, drug testing, disciplinary procedures, misconduct, and just some best practices that you want to make sure that your policies are including. At the end, we're also going to talk about some new laws that have gone into effect this year that you want to make sure that your employee handbooks are brought up to speed, that they are maybe referencing these new laws and that they are complying with them as well. So that's a little bit of our roadmap for our discussion today. So starting off, I'm just going to quickly go through some very kind of employee handbook basics. So having an employee handbook is not required by law. There's not a federal law or a law in South Carolina that says a company has to have an employee handbook, but it's a best practice that every company should have a handbook. And when you have a handbook, you need to make sure that every year you're taking a look and updating that handbook annually. And again, like I said, the fall is a great time to do that. So if you have a handbook in place, is it updated? If you don't have a handbook, we can certainly help you draft a handbook with the policies that we're going to talk about today. So an employee handbook serves a couple different purposes. And one obvious purpose is that it communicates all of the company's policies and procedures to your employees. And so your employees are made aware about what they're supposed to do, how they're supposed to act, reporting procedures, pay procedures, all of those types of things. A handbook is also a good opportunity for the company to communicate their values to their employees. Employees know that there are certain protections that are put in place that the company has, and just generally that the company, has their back, cares about them as an employee. So I think that's kind of one side of an employee handbook. The other side is that it protects the company. So having these policies and procedures in place, you're putting your employees on notice that these certain things are required. And when we represent employers in discrimination cases or wrongful termination cases or whatever it may be, the first thing that we normally ask for is, send me your employee handbook. Let's take a look at those provisions about misconduct or whatever it may be. Send me the acknowledgement that the employee signed saying that they received and understood the employee handbook, even if they didn't read it. Make sure that they are, you can't make them actually read it, but make sure they're signing an acknowledgement that they received it, they understand it, those types of things. So that's going to help protect the company and make sure that you have those policies and procedures put in place, your employees know about it. A company or an employee handbook is only as good as you actually enforcing the handbook, though, and following your own policies and procedures. So if you have them in place, you need to make sure that they are being followed. Next slide. You also need to make sure that your managers and supervisors are trained on how to follow and enforce these policies and procedures. Managers, supervisors, they are a lot of times the front line of defense in working with employees, being put on notice about certain things that are going on in the workplace. So they need to know what procedures are in place and how to enforce those. Employee handbooks are not a one-size-fits-all. So, an employee handbook is going to be based on your type of industry. It's going to be based on the size of the company. There are certain laws that apply to large employers that don't apply to small employers, different employee thresholds. It also depends on just your company and your unique practices, how you carry out things within your business. And so, when we draft handbooks for companies, we do kind of use a template at first, but then, we have to get a lot of information from you all, and there's got to be a more in-depth conversation that takes place so that we can really customize the handbook for your company. So you just want to be leery of just like downloading handbook templates off the internet, because a lot of times what ends up happening is those handbooks may have language in them for a larger employer that doesn't apply to your size of business. You could be subjecting yourself to laws that you actually don't have to follow because of your size, or you could be leaving out certain provisions that you need to be including. And so if you have an existing handbook that maybe you're using from some kind of template, just shoot that to us. Let us take a look at that for you just to make sure that it has everything it needs to. Next slide. Okay, so for South Carolina has an at-will disclaimer safe harbor statute. So if you are operating in South Carolina, your employee handbook for here needs to have this at-will disclaimer, and it needs to be in a certain way. So it has to be underlined in all capital letters on the first page and signed by the employee. Next slide. So here's an example of that. This is the front page of an employee handbook. It's got that large at-will disclaimer, all capitals, underlined, basically putting the employee on notice that they are at will, that the employee handbook itself does not create an employment contract, and that they can still be fired for any reason, no reason, with or without notice, all of those things. And then the employee is actually signing that. And if you have some kind of front cover on your handbook, that's fine. This just has to be on the very next page, or it can actually be on the front cover as well. So you want to make sure that your handbook definitely has this disclaimer. That's kind of South Carolina Handbooks 101. Okay, next slide. Okay, so we're going to talk a little bit about what policies you want to make sure that you're including in your handbook. Next slide. Okay, so we're going to be talking about most of these in more detail. Having an EEO statement in your handbook that's usually at the front saying that you're an equal opportunity employer. We're going to spend a lot of time talking about discrimination and harassment policies. These really need to be very meaty policies, and they need to be following the guidance that the EEOC has put out about discrimination, harassment, hostile work environment. We're going to talk about reasonable accommodations. We're going to talk about wage and hour law, certain provisions that you need to be sure you're including in your handbook. Standards of conduct, or this might be your disciplinary procedures, your drug and alcohol policy, complaint and reporting procedures or grievance procedures. And then we're also going to talk about paid leave and unpaid leave. And then workers' compensation. You want to make sure that your handbook has a section that also addresses workers' compensation. Okay, next slide.
Katie, before we move on to the next slide, we have two questions.
Oh, now I see. Yes.
Okay.
Okay. I've not been good at looking in the chat. Okay. What if your handbook is electronic? Can the disclaimer be separate? So that at-will disclaimer under the statute, it has to be on the first page of the handbook. And so I would maybe want to talk to you a little bit more about what you mean by separate, but I would say no, that it needs to be on that first page just so that there's no confusion, and make sure that you are actually complying with that safe harbor statute. So if it is currently separate, I would just make it the very front page, or like I said, if you have some kind of cover page, that's fine, but then it needs to be like the first substantive page of the handbook. Okay, is the signature required on the page with the at-will statement, or can it be on the last page of the handbook? You know, I have seen sometimes employers will do that. We always put it on the very front page with that at-will disclaimer, because that tracks the language consistently with the statute. And so I would say if it's on the last page of the handbook, I would move that signature up just like we had it in the example we just showed, so that we're just making sure we fully comply with that statute, that the disclaimer is being signed on the front page. Okay. Got a couple. Looks like Chris is okay, Chris is chiming in with that statute. Okay, so I hope that answers those questions. I would basically just be following exactly what we had on that slide on the first page, signed by the employee. Okay. So equal opportunity employer, this is typically something that is at the very beginning of your handbook. It can also be, I've seen it in things like in your offer letter, things like that as well. But basically, it's just a statement that the company is committing to providing a workplace free of discrimination and harassment, and that the company is providing policies that make sure that your workplace is free from discrimination and harassment. And so it's typically just a paragraph committing to that and listing the protected classes. Basically, the company says we do not discriminate based on these protected classes, and you want to make sure that that list includes everything. And we're going to be talking about that as well, these protected classes, here in a moment. So kind of more straightforward on that. You just want to make sure that you have that EEO statement in your handbook. Next slide. Okay, so discrimination, harassment, retaliation. This policy is very important to have in your handbook. Under the law, employers are prohibited from discriminating or harassment on the basis of certain protected classes. And those protected classes are race, color, age for people 40 and over, religion, national origin, sex, which includes gender, gender identity, sexual preference, sexual orientation. A recent Supreme Court case has held that sex does encompass all of those things as well. Pregnancy, military status, disability. And so when you're making your EEO statement, you want to make sure that all these protected classes are included, and extrapolate more on that sex classification as well, just because of that recent Supreme Court case. Okay, next slide. Okay, so what is discrimination, harassment? How are these things defined under the law? They're very broad. but it's discrimination is unfavorable treatment based on one of those protected classes that we just went through. And harassment is unwelcome conduct based on one of those protected classes. So if it's unwelcomed, it's based on a protected class, it's harassment. Sexual harassment is a form of harassment. It has kind of its own definition that the EEOC has put out some guidance on. It is unwelcomed sexual advances, requests for sexual favors, other verbal or physical harassment of a sexual nature. Hostile work environment is also a form of harassment. It is severe and pervasive conduct that creates an environment that a reasonable person would consider intimidating, abusive, or hostile. And that severe and pervasive requirement is a little bit of a sliding scale. Severe being, more than just kind of like maybe rude comments or like annoyances in the workplace, something a little more than that. And then generally, sorry if you'll hear the ambulance, generally pervasive conduct, usually that's going to mean it happens more than once, but single incidents can also constitute hostile work environment if they are severe enough. So that's why it's kind of a sliding scale with severe and pervasive. And then retaliation. So our discrimination and harassment laws also have a retaliation provision that employers are legally prohibited from retaliating against an employee who has reported discrimination or harassment, or maybe a safety issue, or they've gone and talked with HR. Whistleblowing, they are protected by statute against all of those, against retaliation. And so this, this discrimination, harassment, retaliation, this applies to the whole spectrum of the employment relationship. So of course you can't discriminate in your recruiting, your hiring, and then of course, once that person is brought on and being promoted, being terminated. And so it really covers that full spectrum. Okay, it looks like we've got one more question. Is it record of Is record of a completed online training record, no signature, showing review of the personnel manual that includes the at-will employment statement. Okay. Okay, so I'm gathering from that they're not actually signing. They're going through some online training where the personnel manual is shown. It includes the at-will statement, but it's not signed. So it does need to be that disclaimer does need to be signed by the employee. So you need to incorporate probably in your onboarding process some kind of mechanism where they can still sign and acknowledge that they have received and that they understand the handbook. And again, that's just really important too when we have to help companies in a lawsuit. We're able to show that you as an employee, you were made aware of our policies and procedures, and hey, you even signed this acknowledgement. So they do need to be signing that. I hope that answers that. Okay. Is it severe and pervasive, or severe or pervasive? I probably need to check the exact language on that, but like I said, a single incident of harassment can be so severe that it constitutes hostile work environment. So probably severe, or although I think it's sometimes communicated with an but EEOC guidance does say that there are certain incidents that are so severe that they don't need to take place multiple times. And so if you have other questions about that, more specific questions about that, you can, I can talk to you offline too. Okay. Okay, so let's move on to the next slide. Okay, so when we're looking at sexual harassment, or really hostile work environment claims, harassment claims, there is an affirmative defense that exists for employers under case law. And so if the employer is able to show that they took reasonable care to prevent and correct harassing behavior, and that the plaintiff unreasonably failed to take advantage of corrective opportunities, aka did not take advantage of reporting procedures, those types of things, then the employer is able to fulfill this affirmative defense to a hostile work environment or harassment claim. The defense can be lost if the victim has to report harassment to the alleged harasser. And so we're going to talk about this a little more on the next slide, but your policy needs to have multiple people that the person can report to. So if your policy says only one person, like you have to report to your supervisor, well, what if the supervisor is the person that is doing the harassment? So you can't require them to report to the alleged harasser. No alternative methods of reporting in the policy, so there has to be multiple methods of reporting. If supervisors fail to follow up and address complaints, if supervisors fail to report to HR, and if HR fails to investigate. So if any of these things are taking place, this is basically showing that the employer hasn't exercised reasonable care to prevent and correct that harassing behavior, and they won't be able to take advantage of this affirmative defense. So next slide. So based on that, what does your discrimination and harassment policy need to include? It needs to have a clear prohibition against discrimination and harassment and creating a hostile work environment. It needs to have the definitions and a list of examples of what kind of conduct constitutes discrimination and harassment. And of course, there's no exhaustive list. So you also need to state that. You need to have some examples, but then also be able to say, this is not an exhaustive list. Harassment and discrimination can take place in other ways. Your policy needs to require immediate reporting. So supervisors that are put on notice that are told by an employee that they are experiencing this conduct, they have to immediately report to HR. Employees also need to be immediately reporting it. If a bystander or another person that is not experiencing the conduct, but if they see it going on, they need to be reporting it. Again, we need to be encouraging people to put the employer on notice so that the company can step in and make sure this kind of conduct is put to an end and not taking place. There needs to be multiple people that the person can report to. So you could say, that you can report to any member of our HR team, your supervisor, the CEO. There needs to be a few different options. And, in the case that the harasser is in one of those positions, there's then an alternative. There needs to be multiple ways to report. You can send an email, you can come in person, any of those things. So just multiple ways to report. It needs to address confidentiality. So the company can't promise complete confidentiality, but what you say is that basically any kind of complaint and ensuing investigation will be handled as confidentially as possible, as in it will be handled on a need-to-know basis. So only the people involved in the situation, the person's supervisor, those types of things. But your policy does need to address confidentiality. And this is to encourage employees, again, to report, making sure that if they do report, it's not going to be broadcast in any kind of way. It's going to be on that need-to-know basis. You need to have a statement that an investigation will take place. And this again kind of goes back to the confidentiality. HR is going to have to interview the people involved, take statements. And so that investigation will need to take place and take place promptly. You don't want to be getting complaints and then letting time go by, and then maybe the situation is getting worse and worse. And so a prompt investigation has to take place. Your policy also needs a non-retaliation provision, making sure that the employee knows that they will not be retaliated against for reporting. And the language of the policy should encourage reporting and not discourage. And so while you have to require immediate reporting, the language otherwise should be encouraging and kind of soft, not overly harsh, if that makes sense. And then that last, I know it's cutting off a little bit because I got wordy with my slides, but that last part says disciplinary repercussions. And so you need to be stating in your policy somewhere that if this conduct is taking place, it could lead to discipline up to and including termination in the company's sole discretion. Okay, I think that's everything there. Let me check the chat real quick. Okay. Okay, next slide. Okay, so moving on from discrimination and harassment to talk about accommodations. You also need to address accommodations in your handbook. So under the law, the employer has to provide a reasonable accommodation to disabled employees absent undue hardship. And employers are also required to engage in this interactive process with the employee to determine if the employer can provide an accommodation that can allow the employee to fulfill the essential functions of their job. This undue hardship standard under the ADA means something that causes significant difficulty or expense. And that analysis focuses on the resources and circumstances of the particular employer. So it's really on a case-by-case basis, and courts look at things like how big is the company? Do you have plenty of staff that can take over some of this disabled employee's duties? Your income, revenue, things like that. All that is taken into account in determining undue hardship. Religion, employers also have to provide reasonable accommodations absent undue hardship for religious reasons. And the undue hardship standard for religion is actually lower typically than the ADA. For a long time, the standard was if the employer could show anything more than a de minimis cost. So if the accommodation is going to cost them anything more than what's de minimis, then they were meeting that undue hardship threshold. There was a new Supreme Court case this year, though, that has dialed that language back a little bit and basically said that undue hardship is shown when there's a substantial burden in the overall context of the employer's business. And so this new standard does kind of bump it up a little higher to what is probably the ADA. It's still a little bit of a gray area. Undue hardship is really hard to determine. You need really good, provable records to show undue hardship. And so that is definitely something you want to consult legal counsel about so that we can kind of talk through that with you. And then you also have to provide accommodations to pregnant workers. And we're going to talk more about that at the end of the presentation under our new law section. But basically, your accommodations policy needs to say, we as an employer will work with an employee to provide a reasonable accommodation. Oh, this might be on the next slide even. Sorry, Brittany. Yes, okay. That, the employer will engage in an interactive process to determine if a reasonable accommodation can be granted in the employer's sole discretion. So you basically want to say, like, we as an employer will comply with state and federal laws and determine if an accommodation can be granted in our discretion. And you need to include a procedure for requesting an accommodation. So employees know who to contact. That's probably HR if they need an accommodation. So make sure that your handbook has this policy. Okay, next slide. Okay, so moving on to wage and hour. This is also should be a very kind of meaty section of your handbook, talking about wage and hour issues and pay issues. You'll need to have employee classifications in the handbook. So definitions for your exempt and non-exempt workers. You probably also want to define full-time and part-time if you have both full-time and part-time employees. If you have temporary employees, you might also want to provide a definition for that. For your exempt and non-exempt classifications, typically you don't actually want to put in the FLSA threshold for whatever it is at the time. It's been the same for the past several years, but they're always talking about raising it, and they actually just announced that they would be raising it potentially. And so you don't want to actually put in a number in there. You basically just want to say that, you know, exempt workers are exempt if they qualify as exempt under federal law, that type of thing. But you do want to have those definitions in there. Recording time, you need to have a section that addresses how employees are to clock in, clock out. If you have some kind of software that they are going to be using to do that, you want to make sure all those instructions are in this section. And you need to have a clear prohibition against working off the clock. So again, employees don't need to be taking work home at night, not clocking in, and they're working at home. They have to be clocking in and out so that they're paid for the time they are working. You need to have an overtime section. What is overtime? Who gets overtime? And so that needs to say that your non-exempt workers are qualifying for overtime or allowed to get paid for overtime. And again, that's why those definitions are important that we already went over. And you need to have a requirement that overtime has to be pre-approved. And so you don't want employees just working overtime whenever they want to, and then the company is having to pay them time and a half. So they need to be having any kind of overtime approved. And if it can't be pre-approved, typically it needs to be, but I guess I could think through a couple situations that we've had with employers. But if you have any questions about that, just reach out to us. If you have a company that sometimes at certain times of the year where employees are going to be required to work overtime, then you just kind of want to have a sentence in there that basically says at certain points you may be required to work overtime. So I'm thinking about things like plant shutdowns or like seasonal work, those types of things. You want to make sure that's covered in your policy as well. Meals and breaks. This is another section that we're going to talk about with the new pregnancy laws as well. You want to go over what break time is allowed for at the company. So there's actually not a state or federal law that says you have to provide an employee so many breaks throughout the day. There is guidance, there is law that says typically breaks less than 20 minutes, those have to be paid. Meals, usually 30 minutes or longer, don't have to be paid. But you can choose as the employer how many breaks you want to provide throughout the day. And so that needs to be stated in your handbook as well. Okay, next slide. Okay, you need to have a payroll section that tells the employee when payday is, how often they are getting paid. You need to lay out what deductions will be coming out of their paycheck. So those required deductions by state and federal law, and then also any elective deductions such as 401k or health insurance, those types of things. You need to have a policy that basically says, you know, the company will not make improper deductions, and will do our best to correct any kind of pay discrepancies. You need to have a requirement in there that if an employee feels like their paycheck is incorrect, if an improper deduction has been made, then that employee needs to report it as soon as they find that error. And then the company needs to have a commitment to fixing that on the very next paycheck. So as soon as possible, basically. So a reporting procedure in place for improper pay. And one of the reasons that needs to be in place, other than, I mean, it's just a good policy to have in place, but there's also a safe harbor under the FLSA for exempt workers. And so if there is some kind of just honest mistake in pay, as long as it's not this pattern of paying employees incorrectly, if it's just like some incorrect deduction or honest mistake, there is a safe harbor for employers that has certain elements. So if the employer has a policy prohibiting improper deductions and including a complaint mechanism, if they reimburse the employee for any improper deductions, and again, that needs to be done on the very next paycheck as soon as possible. And if they make a good faith commitment to comply in the future, the employer will not lose the exemption under the FLSA for exempt workers. So again, that's why it's important that your payroll policy have all those things that we talked about as far as a reporting mechanism, all those types of things. Okay, next slide. Okay, so moving on to standards of conduct. So this might be like your disciplinary policy, or just the section of your handbook that lays out the standard of conduct that employees will be held to. You do need a section on this. It needs to include a list of specific conduct that is prohibited. And then it also needs to include just catch-all language. So things like, rude, offensive, unprofessional behavior, insubordination, things like that are more catch-all, so that again, when we're looking at an at-will employee, even though they can be terminated for no reason, for any reason, when we handle lawsuits for employers or help them, we're always looking at these sections, the standard of conduct section, when employees are terminated, and making sure, it's nice to be able to point back to a standard in the handbook. And so you have to communicate what constitutes misconduct under your policy. Let me check real quick. Looks like we got another question. Okay, so this person is asking, they have an accommodation section, but it sounds like it only is under the ADA section of their handbook. Has a discrimination harassment policy, but do we need to specifically add religion and pregnancy, etc., even if pregnancy is mentioned elsewhere? So I think if pregnancy is mentioned elsewhere, it's probably fine. You definitely need to add religion, but I would also just add pregnancy as well in that section, and it's fine if you have it later on in the handbook, just so employees, there's like a one-stop shop in the handbook where they know who qualifies for an accommodation and how to request one. So yes, you do need to add religion, and it is good that you have pregnancy in there already, but I would just probably group it in with the other two as well. Okay. So disciplinary procedures, this doesn't necessarily need to be stated in your handbook, but I thought it would just be good to go over as far as when you're having to discipline an employee. This needs to be done in writing. It needs to be done in writing. It needs to be signed by the supervisor and the employee. And so basically an incident report or a disciplinary report type of thing. And so it needs to be in writing, have the employee's name and date, needs to describe the incident, and it needs to sufficiently describe the incident. So we need details. It needs to cite to the rule or policy that's been violated. So again, that's why it's important to have that information in the handbook. And it needs to be more than on October 2nd, Jim violated the employee handbook. It has to be more than that. That's not gonna, that's really of no use, to be honest. It needs to say, on October 2nd, Jim was late for work. This was his 10th time being late in the last 20 days, pursuant to section whatever of the handbook, our attendance policy, late policy. It needs to have enough information that it puts the employee on notice of what's happened. And then that's also important if some kind of litigation could ensue later. It needs to include the disciplinary action that the company is taking against the employee. It needs to include what would happen if this misconduct continues. And then again, like I said, signed by the supervisor, signed by the employee. If there are other witnesses that have been involved, taking statements from those witnesses, or if certain oral discussions have been had, putting all of that in writing is the best way to do it. And when supervisors are having to address misconduct with an employee, they need to have a second person in the room, preferably HR, but if not HR, maybe another supervisor or manager. And so again, this is just really important. If there's an issue later, like a wrongful termination lawsuit, we're always asking the employer, hey, send over the personnel file. And when there's signed statements in the file, that's always good to have, because then you can show, hey, you as an employee were put on notice that you knew what was going to happen if this behavior continued. So a good thing to do. Okay, next slide. Disciplinary procedures. So some companies have progressive discipline, which is this kind of set hierarchy of, if you offend so many times, this happens, maybe you're put on suspension. If something else happens, then maybe your pay is docked, or whatever it may be. They have this progressive kind of linear disciplinary policy. If you have this, it just needs to have language that basically allows the employer to skip steps in that process, depending on how bad the misconduct or behavior is. You really don't want to lock yourself down to this set hierarchy, because the double-edged sword of that is, you have an employee that comes in later and says, well, I was terminated, and according to this progressive disciplinary policy, I should have been put on leave without pay first, or whatever it may be. So you need to have some flexibility built into that progressive disciplinary policy. Basically, you have to have language that says, or you need language that says, the employer can discipline in its sole discretion up to and including termination. You need to be consistent in carrying out discipline. And again, I know that sometimes these issues are hard. It's on a case-by-case basis. Some things are more egregious than others, but to the best of your ability, you need to be consistent, because otherwise, if you end up terminating or disciplining somebody in a protected class, and you didn't do the same for an employee outside of that protected class, you have an issue brewing at that point, a potential lawsuit or complaint. Grievance procedures. So companies will also need to, or it'd be good to have a policy that basically lays out, if an employee has a grievance, a procedure for reporting that. And again, that's been absorbed a little bit in like your anti-discrimination and harassment sections, but there could be other grievances, of course, besides those things. So who they can go to report. Again, I think a couple people is always best for that. And then there also needs to be just another statement of non-retaliation, that the employee is not going to be retaliated against for following this grievance procedure. Okay, looks like we've got another question. Okay, so I ran across where the employee refuses to sign the write-up. Any advice as to handle it besides accepting it? So I think I would first tell the employee that, them signing it is an acknowledgement that they've received it. They're not necessarily saying that they agree with everything that's written down. I mean, you can try at first saying that, like, this is just basically an acknowledgement that you received it, not that you agree with everything that's being said in it. And then if they still won't sign it, I think that's insubordination and another reason for them to possibly just have another notch against them. And I think that just needs to be noted. Like, if they really refuse to sign it, they need to be disciplined for that. And it just needs to be maybe noted on that discipline form, the employee refused to sign this, any reasons that they give for refusing to sign it. I think that's probably how I would handle that. Chris, if you have any other ideas too, feel free to chime in. Okay. Have a witness note that on the form. Yeah, so Chris is just saying, yes, have that noted on the form. Okay, so sorry, one more follow-up. It is okay if employee doesn't sign, still disciplined? Yeah, that's right. It's still good evidence of discipline. Okay, so drug and alcohol policies. This typically follows, right after your standard of conduct or misconduct, your disciplinary procedures. You need to have a prohibition against employees working while under the influence. There's currently no laws that prohibit alcohol and drug testing in South Carolina. There is an intoxication defense that is available to employers under workers' compensation laws in South Carolina. And so basically workers' compensation does not have to be paid out if the injury or death was occasioned by the intoxication of the employee. So there is this kind of safe harbor there under workers' compensation laws. And I'm still going to start going through these a little more quickly because I know we don't have that much time left and I want to get through everything. Okay, next slide. Drug testing, drug laws. This is just an ever-evolving area. It's becoming more complicated for employers to navigate. Marijuana continues to be illegal under federal law. It's illegal under South Carolina law. South Carolina does not have medicinal marijuana. Of course, we don't have recreational marijuana. We do have hemp-derived THC, which is legal. And this is, I think, one thing that employers are having to navigate is that potentially this hemp-derived THC can pop up on drug tests. I think what ends up happening probably more often is that when an employee fails a drug test, then they turn around and say, well, it's because I was taking CBD gummies or whatever it may be. They try to potentially use that. And so, drug testing, you need to have a policy in your handbook, depending on what your organization, what it decides to do about drug testing. This needs to be in your handbook. And this is going to be different for different types of employers and potentially who you choose to drug test, different types of positions. Obviously, if you have positions that are handling machinery, driving forklifts, things like that, that is going to be more important potentially for you to do random drug testing. But whatever way you decide to do drug testing, it has to be carried out consistently. So if you're going to random drug test, you need to state that in your policy. You need to make sure you're doing that in a consistent way. I feel like that employers should do post-accident drug testing and that should be stated in the handbook, just because if something happens, you can do post-accident testing, and then the employer is able to point to that if the person fails the drug test and say, if the employer later gets sued for something that went wrong, they're able to say this employee was under the influence of drugs, they failed a drug test. And so I think you should implement post-accident drug testing. Currently, there aren't any laboratory or panel requirements. So you don't have to use a specific type of laboratory or a specific type of panel where you're testing for different drugs. And in the handbook, you basically just need to have language that says, we carry out this drug testing, the employee, you are consenting to be drug tested in this way. So let me look at a couple, the Q&A. Can we prohibit the possession and use of CBD products on company premises and time? Yes, you can. You can prohibit them they can't use CBD while they're at work. Now, if you're in a state that has medical marijuana, if you have a plant or a facility in another state, that might be different. For South Carolina, yes, you can prohibit them from using on company time and on company premises. Again, if you're operating in another state, you need to make sure your drug testing and drug policy complies with every state, which is where employers are also having a lot of issues. Okay. Okay, Tiffany, I think that sounds good. What you did there with the employee refusing to sign. Okay, we do post-accident drug testing. It could be a possible reasonable for the accident. I think that standard of if it could be, yes, I think that's when you should be doing post-accident drug testing. Yes, I think if you have a reason to believe that it could be due to the employee being on drugs or being intoxicated, if you're doing alcohol testing, which I know is a little bit harder to pinpoint, but no, I think having that standard of if it could be is fine. I was encouraged not to blanket drug test. Yes, okay, same kind of thing. Yes, if you have a reasonable suspicion. Yes, sorry if that was if what I said was confusing. Basically, I just wouldn't have a policy. I wouldn't have a company policy that doesn't drug test at all, because you need that kind of backup if you think something's going on post-accident drug testing. But yes, reasonable suspicion is correct. Yes. Okay. I think workers' compensation. You need to have a section also addressing workers' compensation rights. Oh, I'm sorry. Read my own slide. Okay, yes. Drug-Free Workplace Act. State contractors, if you are receiving a grant or a state contract for goods or services worth $50,000 or more, you can implement this Drug-Free Workplace Act policy. And basically, if you meet the requirements under statute of that policy, you can get a 5% discount on your workers' compensation premiums. And so again, it's not for all employers. You have to be receiving a grant or a state contract, but it's also something to keep in mind. Okay, next slide. Okay, paid and unpaid leave. I'm just going to go through this quickly. You need to have a section in your handbook if you're offering PTO, vacation days, sick time, anything like that. Oh, I did have a question that somebody put in before the presentation. They asked if a salaried employee takes more sick days than they're allowed, if the employer can deduct that from their pay. And so, yes, provided a couple things are done. So yes, you can deduct that from the pay as long as you have a policy in place that addresses paid sick days. If you have a paid time off policy in place that addresses sick leave, if they're allotted so many days and they've gone over that, you can deduct that. You also have to deduct the full day. So you can't deduct just a few hours. It has to be a full day of work. So for whoever put that in, I wanted to make sure that was answered as well. So your paid time off policy, it needs to address accrual, how paid time off is accrued. Can it be rolled over? Is it going to be paid out at the time of separation? I think, sorry, I have a typo on there, but is PTO going to be paid out when the employee either resigns or if they're terminated for certain kind of egregious violations, do they lose their right to being paid out? All those are decisions that the company can make. It just needs to be stated in the handbook. You also need to say, of course, that prior approval is required, and if you have some kind of time frame, if they have to request it 2 weeks in advance, whatever that might be, you want to have that in your policy. There is South Carolina job protected leave. So this is protected under South Carolina law. It's unpaid job protected leave. So jury duty, military, that's actually under federal law too. If you have to be a witness and attend court. And then I put voting, kind of. So there's no law that says that you have to give time off to vote, but an employer is not allowed to infringe on an employee's right to vote. So just keep that in mind if you have people that are working on election day from the time before polls open to after the time polls are closing. You know, you need to rethink that and make sure they have some time off during that day to be able to vote. But it's fine to say, hey, your shift starts at 8 a.m. You need to go to the polls and vote before that, before your shift. Okay, next slide. If you're subject to FMLA, you need to have an FMLA section in your handbook. This also needs to be a very meaty section. Who qualifies? How do you request it? Make sure you're saying that PTO runs concurrently. And leave, unpaid leave can also be an accommodation. So remember that. Okay, let's maybe skip through in the interest of time. Yeah, okay, new handbook updates. Okay, so there's been an NLRB decision that came out this year that basically says employee handbooks cannot be worded in a way that would have a tendency to chill an employee from engaging in protected activity. So overly harsh language that makes the employee scared to participate in protected activity does violate the NLRA. And so this is something that it's hard for me to pinpoint exact certain language. In fact, I think we can go to the next slide too, Brittany. But basically you want to have some language that says, you know, nothing stated in this handbook is meant to chill an employee's right under Section 7 of the NLRA. You want to make sure that all of your policies and procedures are serving a legitimate business interest and are narrowly tailored. And this is really something that your legal counsel needs to review. Just take a look at that language. Since this is a new case that has come out, make sure that employees aren't scared to report or scared to participate in this protected activity, that there's not this really harsh language. And so kind of hard to give specific examples, but it's something you need to be aware of in your handbook. Okay, next slide. Pregnancy laws. Chris last month covered Pregnant Workers Fairness Act and the Pump Act. Your handbooks need to be updated to take this into account. So basically, Pregnant Workers Fairness Act, you have to provide those reasonable accommodations to workers with known limitations related to pregnancy, childbirth, or other related medical conditions to pregnancy. They have to be provided a reasonable accommodation absent undue hardship. And a lot of those same definitions are the same definitions from the ADA. So it kind of tracks pretty well with the ADA. But again, if you're running into specific issues, please contact us. But when you're looking at your accommodations policy, you need to be including pregnant workers in that. Pump Act, this is going to need to be somewhat addressed in your break time policy, maybe even your pay policy. So basically, employers have to provide time to pump, and it can run concurrently with the paid breaks you already offer. So if you offer 2 15-minute paid breaks a day and an employee is using that time to pump, then they get paid that normal time for those 2 15-minute breaks. But if they need additional time, you have to provide that additional time. It does not have to be paid, but they do have to be provided that time. Trying to think, there is a small employer exception if you have 50 or less employees, if you're able to show undue hardship. So keep that in mind as well. Okay, next slide. We got 1 minute and try to get through in 1 minute. Okay, new technology, this post-pandemic world that we're living in. Your handbook is really out of date if it's not addressing some of these issues. The biggest one is social media. You need to have a social media policy. Your handbook somewhere needs to discuss social media, because things like discrimination, harassment can take place on social media. And so your policies are going to carry over to those platforms. It's going to carry over to things like Zoom meetings and Teams meetings. If you have employees that are engaging on social media, even if it's outside of working hours, if it affects the working relationship, then the employer has to do something about it if they're put on notice, and all your policies are going to carry over to social media as well, and those virtual meeting platforms. Remote work, hybrid policies. If you have employees that are remote workers working hybrid, you need to have policies in your handbook that address that. And if they're standalone policies currently, let's update the handbook and make sure that's all included in the handbook at this point. Okay, it's 1 o'clock. I don't want to keep you all over. I think I got through most of the substance. It doesn't look like we have any other Q&A or comments in the chat. And so we do have another webinar coming up in November. Denny Major will be talking about overtime requirements and non-compete agreements. So that is going to be a good one. Okay, Brittany, I think that's everything. So thanks everyone for attending. We appreciate it. And again, you'll be given this recording and these slides. Great, thanks.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.